Welcome. Today we're going to discuss an opinion issued by the Trademark Trial Appeal Board in Re Carling Technologies. My name is Scott Slavick. I am the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, searching and clearing new global brands on a rush timeline, reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. The Trademark Trial Appeal Board affirmed refusals to register the two product configuration marks shown for actuators for rocker switches on the ground that applicant Carling Technologies failed to prove that the designs had acquired distinctiveness. Although Carling's design patent ensured exclusive use of the designs for 14 years, the board pointed out that long and exclusive use of a proposed mark does not necessarily mean that acquired distinctiveness has been attained. Under Walmart, product configurations, of course, cannot be inherently distinctive. In determining whether Carling's designs enjoyed acquired distinctiveness, the board first had to determine the degree of descriptiveness of the designs and then apply the factors set forth in Converse versus ITC. Carling admitted that once its design patent expired, third parties were quickly popping up at an alarming rate to sell rocker switches with actuators that applicant admits resembled its own. Because there were a significant number of examples in the record, registrations of the claimed marks may not issue except upon a substantial showing of acquired distinctiveness. Carling submitted declarations from two non-parties attesting to the source identifying significance of the design, but the board found the declarations to be problematic for two reasons. First, the declarations were obviously prepared by Carling or its counsel, and the form nature of the declaration reduced their evidentiary value. And second, the two declarants were not representatives of the universe of purchasers of the goods. Because many similar-looking actuators are on the market, Carling's 14 years of exclusive use had little probative value. Carling provided copies of advertisements, but no data regarding the geographic scope or amount of the advertising, nor the amount of expenditures. None of the advertisements directed consumers to look for the subject design as a source indicator. Although the actuators were depicted in Carling's advertisements, the proposed design marks did not stand out. Given the emphasis in the industry and in applicants' own materials on the non-source identifying features of the goods, for consumers to have any realistic chance of recognizing the applied for marks in applicants' advertising, separate and apart from the multiple other products, the Carling house mark, and even other features of the contour of the rocker switches and actuators themselves, applicants' advertising would have to direct the potential consumer in no uncertain terms to look for the applied for marks according to the board. Carling's sales figures, about $3 million per year, were muddled because they did not segregate actuators from switches. Moreover, Carling did not place the sales figures in context with others in the industry. In any case, Carling's sales may merely reflect the popularity of its products rather than recognition of its proposed marks. Carling argued that competitors had copied its design and that actual confusion had occurred. Consumers had returned defective switches made by others to Carling. The board pointed out, however, that the confusion evidence related to entire switches, not actuators, and the copying also involved entire switches. Based on this, the board felt that it could not find that the particular features of the actuators for which applicant was seeking registration are recognized as applicant's marks. Carling's inaction vis-a-vis policing the proposed marks against supposed infringers cut against its claim of acquired distinctiveness. Although this evidence of copying and product returns had some probative value, it lacked the specificity to show that the copyists and consumers recognized the specific actuator features for which applicant was seeking registration as applicant's mark. Considering the entire record, the board concluded that Carling had failed to prove acquired distinctiveness. One interesting takeaway from this case is whether the 14-year period of design patent exclusivity should count toward acquired distinctiveness. Should the designs fall into the public domain once the patent expired? As to the first question, the Seventh Circuit has required evidence that legally imposed patent exclusivity wasn't the primary reason an association arose. The CCPA seemed to understand this too, suggesting that a long period of patent-required exclusivity by itself amounted to de facto secondary meaning, i.e. a significance or recognition due to a lack of competition or other happenstance, but which is insufficient to support a legally protectable right therein. One can certainly see parallels in patent law, where if someone owns an earlier blocking patent and then gets a later patent on a related invention, that patent owner, in defending off an obviousness defense on the latter patent, can't rely on others' failures to fill that long felt need, one of the secondary considerations of non obviousness, because the blocking patent would have deterred them from doing so. The second question can really only be answered if the Supreme Court decides to clarify their potentially conflicting precedent. In a number of cases from the late 1800s to the mid 1960s, they seem to suggest that once a patent ran out, the patented features were, without exception, dedicated to the public. But then, in the more recent Traffic's decision, they expressly noted they were evading ruling on that argument, at least to the extent it relies on the patent clause of the Constitution. So maybe the current iterations of the court are reluctant for some reason to rely on this concept. Hopefully, we will get more clarity as the case law develops, but in the interim, this case is instructive to see how much evidence the board is looking for when it comes to product configuration trade dress, and how having an expired design patent does not necessarily rule out subsequent trade dress protection. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.